Thank you to all the witnesses for your time and analysis on this. I'd like to start with you, Professor Pardy, and because you're joining us virtually, you didn't have the privilege of seeing the Liberal members of this committee snickering as you were talking about the Liberal government's assaults on civil liberties in the past. But I think that is important context for what we're seeing here, because in your opinion, these are not benign provisions. These are significant expansions of the power of the state to regulate thoughts and emotions and expressions, correct?
Correct, yes.
So when you look at language, and I'll ask you this as well after Professor Alford, but first, Professor Pardy, in your analysis of legislation in the past and your knowledge of statutes, when words are omitted from jurisprudence, that is not what codification of jurisprudence is, correct?
Correct, yes.
So explain in practice, if you are a police officer that is doing an investigation, or you are a judge weighing in on this, how significant is the omission of the words extreme manifestation from the definition of hate that exists in the common law now to the one that C9 puts in law in the criminal code?
Yes, so thank you for the question. And this is really Professor Alford's point. You have a common law, you have a jurisprudential context. The Supreme Court of Canada in the 2012 case of WUCN-Epi describing what was a reasonable limit on freedom of expression. And let's just underline this. They said that this was a reasonable limit, but they also said that this is an infringement of freedom of speech. So what you have to start with in C9 is an infringement of freedom of speech. This definition does infringe freedom of speech. That's what the Supreme Court says. Okay, so this is an infringement from a government that claims to be a government of the Charter and of rights. We start there, and then if you fiddle with the wording, if you leave words out, if you make it detestation or vilification and not and, for example, then you are downgrading the threshold above which you need to get in order to find that this is established, right? So it's a little bit of playing around with the words so as to appear as though you're doing exactly what the Supreme Court said, while you're not really doing that at all.
And I'll go to you on this, Professor Alford. I believe you did review the Minister of Justice's testimony on Bill C9, and in that he said, and I'll quote directly from what the minister remarked here. He was asked about the definition. He said, "This was not an attempt to dilute the definition. It was an attempt to make good on the spirit of that definition and provide clarity to law enforcement." What is your view on the minister's characterization of his own bill, Professor Alford?
It's incorrect. And I would say that the problem is that the courts are going to look at the decision to use this particular language that omits the language from WUCN-Epi that I cited in my testimony and say, well, that's clearly an intentional decision. You made the decision, seeing what was written in WUCN-Epi, to leave this out. Now, the most ominous possibility here is what's going on behind the scenes, is that the government is actually seeking a ruling from the Supreme Court in due course that would lower the threshold to what they're putting forward in this bill. They're saying, well, you said that in 2013. If you uphold what we wrote into this bill, which intentionally left out some of the language that Justice Rothstein, since retired from the court, of course, included in that judgment, that you will then say that this is a reasonable limitation on freedom of speech. And I think that's particularly dangerous.
Explain to me, if you could, Professor, and I realize that hate is inherently subjective, which is the problem that we've been identifying with this, but what would the practical application be in your view? What would be captured by this new definition that isn't captured under the existing definition, just to demonstrate how this dilution and this lowering of threshold is actually happening? Or is there no way to make such a prediction right now?
Well, I think there is, Mr. Lawton. I would just say, if you look at what's happening in the United Kingdom right now, where, now remember, there's no entrenched right to freedom of expression in the United Kingdom. They don't have anything like the Charter, which creates that right. So there you have speech that purportedly abrogates the dignity of individuals or groups. That's the basis for complaints to the police, and arrests are being made on that basis. Now, that's what the language from WUCN-Epi that is left out in the proposed definition of 319 sub 7 would allow precisely that, people to make complaints that what someone's saying is hatred. And the reason why it's hatred is because it's an intentional attempt to infringe their dignity as an individual or members of a protected group. So we've seen quite a lot of this in the United Kingdom, particularly with very charged issues such as competing rights around what's called gender identity issues and women's rights, where you've had many people who felt like they were engaging in good faith, who are now the subject of visits from the police and then arrests because of the complaint that what they've said and the way that they've engaged on this issue is engaging and detrimental to the dignity of the people with whom they engage.
It's a valid point, Professor, and I know that Minister Fraser had mentioned to my colleague, Mr. Baber, that it was, quote, far-fetched to imagine UK-style tweet policing in Canada, and then moments later, he admitted that Bill C-9 will cover what people say on the internet. So very quickly, is that a legitimate concern for Canadians if C-9 passes, Professor?
It's eminently legitimate, Mr. Lawton.